Good morning, folks. This is a webinar aimed at property owners in the Tshwane Metro that will be affected by the new property evaluations that will come into effect as from the 1st of July. That is the start of the municipal financial year. Many property owners are nervous and they want to know how do they check what property rates they are likely to pay, how do they object, and that is why I have with me an expert in property law, a practicing attorney, Hans-Jurie Moolman. Welcome.
Good morning, Cilliers. It's wonderful to be with you.
It's wonderful to have you here. And this is a really important issue for property owners in the city. And let me just give a bit of context before we start. And let me just emphasize that we tried to take the questions that we as the DA and our councillors have received from residents and to put that to Hans-Jurie and to get his answers. And at the end of that, depending on how much time we have, we are going to look at the questions that you have submitted via our online platform. And I'm going to have a look at my phone here. Those questions will be filtered through. The idea is to answer questions that we haven't already asked before, but this is a format where we will be sitting and working, looking at papers, looking at the law, and hopefully answering the most pertinent questions that you have. I just want to emphasize that the deadline for submitting your objection to the property valuation in the city is the 2nd of May. So it's always better to prepare these things earlier, and I'm quite sure that with these questions being answered, you'll be in a position to do so. Just one final word about this webinar before I give Hans-Jurie the context of the Tshwane Metro. If for whatever reason, for technical reasons or load shedding or whatever, the live feed is cut, we will make this video available to those that have registered for this webinar. So Haya, let's get into this, but first a little bit of a context in the city of Tshwane. The last valuation roll, and we'll explain what this means, was done in 2018. So it's quite old. And the reason for this is that the city was placed under provincial administration. It was a prolonged period of about 8 months in 2020, and that coincided with the COVID-19 lockdown. Yes. And so preparing a municipal valuation roll, preparing the process takes about 18 months, all of the deadlines and all of the things that you have to get in place. And so by 2020, the city simply wasn't in a position to do a general valuation roll, and then obtained permission from the MEC for local government in Gauteng to use the 2018 valuation roll until a new roll could be completed. And that's where we are at the moment. And maybe that is also one of the reasons why residents are seeing higher than usual increases in the valuation. But that's the context just for Hans-Jurie's benefit. But let's get to the questions, Hans-Jurie. What are property rates? And how is this charge called property rates different from the other items that you see in your municipal bill?
Okay, yes. Property rates, municipalities all over South Africa have different streams of revenue. Of which property rates is one of the streams of revenue, but it is to be distinguished from services fees because it's a tax. It is regarded as a tax. And a tax is usually distinguished, even in the Constitution, when our national government makes legislation, they talk about money bills. So tax is a form of revenue that is not linked to a specific quantity of consumption, or where pricing happens in accordance to a tariff that is determined. So it's a form of a tax and part of the stream of income of local governments. The legal basis for that comes from our Constitution, Section 2029, that talks to municipal fiscal powers. And in the Constitution, municipalities is given the right to recover rates as a means of income, and then in that very same section, the government was given the instruction to develop legislation, which we now find in our Local Government Municipal Property Rights Act, that specifically deals with this issue. It's a very technical act in the sense that it describes a lot of procedures. It describes a lot of different scenarios, simply because rateable property is not a one-size-fits-all exercise. Besides the national legislation, municipalities are also, in terms of the very same act, required to adopt its own rates policy. So if you're talking about the bone and the flesh and the cells of a body, in terms of legislation, you have the constitution and the law, national law, and then we have at the local level a rates policy and a bylaw to give effect to a rates policy. Now, the rates policy is the legal instrument, the most important legal instrument that one will have to take a look at in conjunction with the Rates Act if you want to determine the situation or the legal situation in a specific municipality. It's not generic because municipalities are allowed discretion, some limited, but they have discretions in terms of how they impose rates. So the important part is, if you ask me, where does property rights come from? It's from the constitution and legislation. And if one can look at other differences between the rates and services fees that municipalities charge, is the whole issue of prescription. Rates don't prescribe, only after 30 years, whilst other services you'll be able to raise a defense to say within 3 years after an invoice was submitted that you're entitled to claim prescription. So that's a very big difference. And then obviously the whole issue of actual consumption. The municipality charges you for your water consumption, for your electricity consumption, and for waste removal, whilst this is a tax where it's not linked to that.
So there's that important distinction. Services, you use an amount of electricity, you get charged on your usage, you use a little bit less, you pay a little bit less.
That's right.
Same with electricity, but a tax is different. It's not dependent on your usage. Now,
that's correct.
The next question that we typically get is, why do all properties not pay the same property rates? And then following from that, why is it that certain properties find that the property rates that they pay increases far higher than other properties?
Okay. And that comes back to that big question, rateable properties. It's not a one-size-fits-all. If you look at the legislation, the method in broad terms of how rates are determined is actually a factor of the market value of the property. The correct terminology is actually a ratio. And in the legislation and in the property rates policy of the municipality, you'll find those ratios. So the Act allows for different kinds of property to which a different ratio is applied. And then obviously the most important part is that market value is used as the yardstick. So that ratio is applied to the market value of the property to determine what kind of rate should be charged. So although it's charged or it's calculated once, municipalities are allowed to charge it on a monthly basis. So it is calculated for a year, and then every year it gets adopted, and for that year the total amount is added to your invoice in monthly installments, if I can put it in that way. Although it's not an installment, but it's charged over a period of a year by most municipalities. Otherwise, you would have paid it all at once, and I don't think a lot of people would have been able to afford that.
So as I understand it, you almost have three components here when you're talking about that charge called property rates. The first component is what do you do with your property, and that will determine in what category it is. So do you just live there, or do you do business there, or do you farm there? And that's where you get the different categories of property.
Yes.
But then as part of that, you also get rights of a municipality to say, even though you say you just live there, what you actually do is you run a Bitcoin mine, or you do something else. So that's the first determinant. The second component, as I understand it, is then this market value, the market value of the property. And there you also look at the categories, because, say, for instance, agricultural land, your rates on agricultural land will be will be less than residential property.
Yes.
And then finally, the last component of property rates is what tariff the municipality then places on the different categories when it approves a budget. And where we are now, if I understand it correctly, it's at that market valuation phase. That's what the valuation role is for. Perhaps just give me an indication if I got that right.
You've got it 100% correct. The property use, actually the Act talks about the actual use or approved use. So usually when you conduct certain business or certain activities of land, you'll get approval from the municipality, and it is recorded, that use is recorded with the municipality. And that is usually the primary determination of the kind of ratio that will be applied to your market value. But you also have scenarios where the use is not determined, but the municipality or somebody establishes that you are using that property for a specific use that you haven't registered for. And it can happen. In some municipalities, they will charge you for the actual use, or they will have an alternative category that they impose tax. In fact, there was a court case about that.
It's almost like a penalty.
It's a penalty charge, a default charge. So if you haven't approved or don't have the correct approval, they will charge the default charge, and then and in that instance, it was a far higher rate than you would have paid for the actual use. But it's a way from local governments to discourage a situation where people don't use their property for the right or for different purposes than it was properly zoned. But you have it absolutely correct. So
having understood the concept of property rates, maybe you can describe for us in as simple terms as you can, because as we can hear, it's quite technical stuff. But in the simplest terms that you can, what method is used by a municipal valuer when determining that middle aspect of the property value?
Yes, the Act actually prescribes that a market value should be used as the determining value. Just a little bit of background to that. The determination of a value is usually done by a regulated profession. In South Africa, there's a valuer's profession. Valuers get trained. They obtain a qualification, they undergo training under a valuer, and then they get accredited. And
almost like an articles that a lawyer would do.
Much the same. It's also regarded as a profession. So the Act prescribes that the city valuers, in fact it requires a designation of a city valuer or persons employed by municipalities, must meet those requirements. And for that purpose, obviously, when the Act prescribes that they must use a market value as the basis upon which they apply the ratios, the city valuers will use the recognized methods prescribed by the profession, but also in terms of case law. There are many court cases where this whole issue of market value has been established and the methods that should be used, and usually they say the differentiation between valuers, qualified valuers, is not more than 10%.
So it's that precise. It should be that.
It's almost an exact science.
Wow.
It's not an exact science, but it's almost. But you also see it in the legislation that there's a distinction between deviations of 10% and 10% and more. But what the valuer will do, usually in terms of practice, the general practice is to conduct inspections on property to determine where its location is, what kind of improvements there are, and then to collect data of comparable sales. And in most cases, they use the sales that occurred in the last 6 months of similar property or comparable property, and they use those realized values as the means to determine what the market value is. We also talk about the willing buyer, willing seller scenario, what somebody in the open market would pay for that property. With municipalities, it's slightly different, and I think it's important that people know this, because I think that is where some of the disputes occur. City valuers are not obliged to conduct physical inspections. They can make use of other methods like satellite images,
Google Earth,
Google Earth, and all that kind of methods. And then they can conduct, in a layman's terms, they talk about a desktop exercise. And in many instances, I think it's also used to catch people out if the use is different. But in most instances, some of the important information to establish market value goes lost. And I think that is sometimes where what will be the main reason why one will have a dispute about property values.
and a valid dispute.
A valid dispute. So when you will do your own valuation, we can perhaps talk about that. Your own valuer will do the correct procedure and obviously conduct an inspection and see whether that property or that valuation was done correctly.
So what I'm getting is, and I'm using simple terms that are not a valuer's terms, to say that you can often get an extrapolation. So you sit at your computer, you look at a map, you say this area, you extrapolate information, and in that extrapolation, in other words, taking what is valid for this property and applying it to similar properties, there might be mistakes that creep in, and it's there that a property owner will have an objection that has got a good chance of being upheld.
Yes, that is correct. And to all credit to city valuers, it would be a daunting task if you talk about the full extent of properties in a city like Tshwane, to conduct a physical inspection on all properties. And I think that is where the latitude in the legislation is given to allow them to make use of other mechanisms. So
explain to us, we've gone into the method for valuation, and it's clear from your answer that this kind of valuation is not the same as necessarily going to the estate agent and saying, do a valuation for my property. Because you often, if you want to sell your house, you say, just get the estate agent. So it's clear that it's different in that sense, and maybe you can comment on it. But also maybe if you can describe the putting together of a general valuation role for us, just in broad terms. We'll get into the details in the subsequent set of questions.
Okay, yes. Estate agents are people that can give you a good estimate in terms of property values. So there wouldn't be anything wrong with asking an estate agent, because usually they will surrender that information without charging you for that. So I think there's a room for that. The difficulty comes with legal disputes. The moment any legal dispute can evolve into a situation where you can get yourself into a court. I don't think everybody wants to go to court, but one has to anticipate the prospect of the likelihood of a dispute that you now use an internal procedure in the municipality may one day end up in court.
Especially your bigger property owners.
Exactly.
Or if you get such an increase on your business property that in fact threatens the viability of your business, you are probably going to be one of the candidates that heads to court.
That will probably eventually end up in court. And then a sworn valuer or a qualified valuer should be the person to approach. It's going to cost you money, but to succeed and to be able to prove your case, experts or valuers are regarded as experts. And in court cases, experts are not eyewitnesses. They are not regarded as eyewitnesses, but they are assistants or people that provide a judge or a magistrate with knowledge to enable them to determine the case. And in cases where you make use of experts, one will use an expert. And when you do so, I would also recommend that you make use of somebody that is firstly able to do city or proper city valuations and understands the environment, and can also assist you with objections. And then more importantly, that person must be prepared to testify if it comes up to having two different valuers disputing each other. That person must be willing to testify. We've had many cases where clients went to experts, engineers, and then they tender a report, a beautiful report, and everything you need. And when you call the person and say, well, now your report has to be defended in court, the person will say, but I'm not prepared to go and testify in court. So all those factors are important that when you want to raise a dispute and want to make use of an expert, make use of a sworn valuer and a person who is willing to do the job.
Great. So, general valuation role, it's a process I mentioned every 4 years. What can the property owner expect? And I've mentioned the deadline here in the Tshwane Metro is the 2nd of May. What can the property owner expect in terms of to be informed of? What should they look at before we get into the details of an objection?
The Municipal Property Rights Act prescribes a whole process. In terms of cities, it usually happens every 4 years, valuation role, and in terms of smaller municipalities, it's 5 years. So there's a whole time span where property values may differ in that whole period. But usually the process in terms of where the public gets involved is where the valuation role is published and they are afforded the opportunity to provide input. And that is, I think, where you are now, where people can, they've done evaluations, they've determined the values, and now persons who may be aggrieved by the result will have the right as individual property owners to dispute, or the word in the Act is object to the process. And the method of doing so differs from municipality to municipality. If you go onto websites of municipalities, some of them will have proper complaint or objection forms that you can complete. But the default position is to make use of the form, and I can make it available to people that are part of this. There is a default form that is prescribed by law. That you need to complete.
It's in the regulations.
It's in the regulations, yes.
Municipal Property Rights
That's
Act.
right. And why I recommend that you make use of it, you don't want a situation where at a later stage somebody says, but you didn't follow the right procedure. I support idea to, or the whole idea of overkilling on procedure and making sure that whatever you present is done in the right procedure or legal procedure in order to avoid the situation that whatever you do is avoided or not dealt with because you didn't follow the right procedure.
So we are in that objection period I mentioned again, and I'm going to keep on saying the date because it's important. You know, it's like handing in an assignment at school. It doesn't help waiting until the 1st of May. Start doing the work now. It's the 2nd of May. That is the deadline for the objection of the Tshwane Metro. And now I'm going to start asking you, Hans-Jurie, some of the more specific questions about the objection process that we, through our councillors, have received from the public. The first of these questions is, what would typically be the grounds for objecting once you have done your perusal or you've got your notice to say this is your valuation?
So yeah, I think the two main grounds that you will have an objection to is firstly the value that was determined. That is the most significant one, which I obviously believe will have to make use of the expertise. And the other one is if the rates or the ratio that was applied was incorrectly applied in terms of your use or approved use. So if they've used the wrong formula, or where you are rated for something totally different. So the important part would be to make sure that what is reflected on the valuation roll is the correct value. As I said, you can make use of the estate agent to get an estimate or some idea. And then the other part is to look at your current zoning and make sure that the ratio that is applied by the municipality indeed fits that specific use. So that
and to maybe give an example of this, you're the expert. I'm just a politician who studied law at university. But for example, you know, there's a certain ratio of residential to agricultural land and so forth, and you have to make sure that those things are according to the law.
Yes, agriculture is an interesting scenario because there are a lot of rebates given to agriculture because certain services are not provided to the agricultural industry. So your rates policy would usually discount those or have a specific discount because the municipality It's when the legislation came into operation, it was a very, very ambiguous issue.
Oh yes.
Because
There are certain farmers and owners of small holdings who
Yes.
to this day say, but we don't get these services.
Yes.
We've got gravel roads, but unfortunately, as the law was passed, we've got wall-to-wall municipalities, so everybody pays essentially property rates unless you fall into the exclusion. But I don't want to get to that immediately. So the most folks who own a property and think that the valuation is unfair, they don't have money to go to a professional valuer. What kind of evidence do you think the folks who they don't necessarily want to end up in court, they don't have that kind of money, they're ordinary people, but they think this is unfair. Can they, for instance, look at, I paid this for my house only 3 months ago or 6 months ago, or my neighbor, and then point the municipality to that, to say, hey, I think this is grounds for you to look again?
It may. I think if you look at the objection form, that is, for instance, one of the questions that they ask that you need to compete. So it may be a determining factor. But if you look at the method that is used to conduct a evaluation, they don't only look at one transaction, they look at different transactions. So if it is significant enough to say that it should be taken into account, it may probably do so. And I fully understand that most people, especially poor people, but there's also in the legislation, there's also exemptions for poor people to the extent that there are a lot of rebates for elderly people.
And we'll get to
those.
those.
We're not going to get to that. But the important part is that you can use that. But to be honest with you, if I was as a lawyer, would have to give somebody advice, one will have to make sure that if you are going to end up, firstly, your objection is going to be considered by valuers. So they are going to apply their knowledge. And if they apply their knowledge and you want to go further to the Valuation Appeals Board or panel,
you want to strengthen your documents.
You want to strengthen your documents, and there are two valuers, expert valuers on that panel that considers the matter. So they will apply the almost exact science to whatever you have to present.
Now let's get to that form, but first, we often hear this argument to say, I don't necessarily disagree with the valuation of my property. Say, probably paid 2 million for this of 6 months ago, it's valued for 2 million. But what bothers me is the increase, because a few years ago, the municipality said this property is worth 750,000 or $1 million. Now suddenly it's 2 million.
Yes.
So I agree it's probably worth 2 million, but the effect on my pocket as a consumer to pay double or 75% more is I can't accept that. Is that a ground for objecting?
It may be, because in the legislation, the Minister of Kochta, in consultation with the Minister of Finance, can impose upper limits in terms of what the maximum increase is. I have recovered or managed to get some of those publications where they've imposed limits. It's actually supposed to be annually, because in my view, if you want to look at the purpose of giving the minister those powers, it is to take into consideration the economic conditions in the country of the times, because that's also part of unconstitutional, impermissible rights, is to look at the economy and the effect of the economy. So that is ideally, it should be limits imposed by the minister.
Just as an aside, when is the last one? Because I had a desktop research on it and I found a very old one.
Yes, I
where the minister,
2009.
2009, I think the minister said the limit would be, the inflation rate.
Yes.
But is your understanding, and I don't want to test you here, because is your understanding that thing should be updated every year? It's not something, the 2009 decision doesn't necessarily stand in 2025.
Yes, I think it should be updated. If you look at the whole issue of rates, apart from the powers of the minister to impose upper limits, the legislation also makes provision for an equitable approach to this. And I will qualify that. For instance, if a municipality imposes a new category of rates, and it has a major impact in terms of increase in the rates that a consumer has to pay, then the Act prescribes that it has to be phased in. You can't do it all at once. The general terminology for that is a tax shock. It's very difficult. You don't find the word tax shock in the legislation. But if you read the legislation and the way it approaches citizens, it can never amount to a situation where you impose a shock on people and you put them out of business. It has to be phased in, it has to be equitable, it has to be fair. And if there is a significant increase, I think planning needs to go into to phase it in over a year or 2 years, to increase the rates, but not immediately. Perhaps in year 2 or 3 or 4, add an additional amount so that it becomes more palatable for your residents.
And I suppose when that comes to a dispute in court, how many people are affected by that, I suppose will be one of the factors in considering what is reasonable or equitable.
Yes, I think that is where the whole issue of constitutional impermissible rates comes in. There's one case that where the legislation or increases were challenged. Coincidentally, agricultural farmers in KwaZulu-Natal, the KwaNalu, the agricultural union in KZN, and there they were confronted with a rapid increase, and they applied in a blanket way for everybody and say it was unfair in terms of the economic circumstances, and they did not succeed. So if you want to do a case or pursue a case like that,
it's untested still.
It's untested. So it's untested. But there may be in the future maybe a situation where that comes into play, and where one should also start asking the question: but what am I getting? What is the municipality delivering? I have to keep paying, but the money that I'm paying, whether it's rates or whether it's tax, is not used for the purpose that I'm paying it, and we're carrying the brunt of the economy that's not going the way it should go, and that is something that should start playing a role, and maybe that is something that didn't exist 20 years ago, but should now be taken into account.
So that answer leads me to the next question, and that is one that we often also get: do I have to use the prescribed form? Now, what you said before was you would recommend using the prescribed form. And if folks look at that form, it's got all sorts of details that you have to fill in. Do you have a pool? Do you have an outbuilding? Do you live in a residential estate? So all of the things which common sense would tell you would be factors in determining the value of the property, you've got to put in that form. But now, do you have to use the form? Because people might think that if I use this form, I might be slapped with a higher valuation than the one that I received, the one that I perused.
It's a good question. The form is actually to solicit, if I can go back to the method used by city valuers, it solicits more information than the city valuer may have from a desktop exercise. So it may give impetus to increase the value. And why I say it may pose that risk is that a valuation role can be supplemented. And the legislation allows for the supplementation of a valuation role, and that is where rates have been lower than it was supposed to be. The objective would be to reduce it. So to avoid that, I think one should go back to the method is to get an estimate from somebody that can give you to say, well, if there's a likelihood or any reason why your property can increase or have an increased
value,
there's
that risk, and you just be careful. Yes. Proceed with caution.
Go to the estate agent and ask the estate agent. But if you appoint a valuer will also immediately, before you raise your objection, be able to tell you, but listen, don't take that risk, because you are really facing the prospect of this happening. So it's a very difficult discretion you need to apply before you object.
Yeah. Now, that's for the prescribed form. Whether you decide not to use it, let me just give you some context in Tshwane, how they advertised the perusal of the roll. They said that it's open for perusal. Go look at the municipal offices. Go look on the website. There's a search engine. But then obviously the municipality is also obliged by law. It's a step that they have to take to notify you
Yes.
on either the piece of paper that you get with your monthly charges to say draw your notice to that, or electronically, but they have to do that. Sorry, you want to say something?
No, in addition to that, I think that it's also important to know that the Act prescribes, and the regulations prescribe certain minimum information that must be contained on the evaluation.
Perhaps we can quickly look at that.
And yeah, the particulars of the property, the particulars of the owner. I've had a scenario where municipalities refuse to provide the particulars of owners because of the Poppy Act. Nowadays, a lot of people think the Poppy Act is a prohibition on the publication of any information. It is not. If it's used for a lawful purpose, obviously it shouldn't be an impediment. But the legislation prescribes that information must be provided in a valuation role. Now, the valuation roles that don't comply in terms of case law can also be challenged on that basis. And in fact, municipal councils, the Act makes specific provision for municipal councils to intervene and to look at technicalities that are not correct. But it's a very strongly regulated process. It's a strongly regulated publication, and the information that must be provided, and the purpose of that information that must be provided, is to enable whoever makes the decision to make an informed decision.
In other words, what you're saying is that perusing the valuation roll, I'm not just entitled to see the details of my property, I'm also entitled to see the details of other properties.
Yes.
Is that what it comes down to?
Yes, that's my view.
That's your
People
view,
make
of course.
differ, yes.
Yeah, and it seems to me to be an important principle, because if you're going to make a comparison of whether this whole thing is fair, not seeing certain details of other properties as compared to yours that might be in the same area, that might be one of the things that renders this.
I agree.
And then putting that in writing might be an important principle to see what the response is, because there might be a case against the municipality later on.
For purposes of consistency.
For the purposes of consistency.
In determining values, I fully agree, and that's why I said there's a lawful purpose to the public whole issue. It's not just public participation.
Yeah.
It's trade also and comparing values,
Yeah.
and the whole exercise that gave the values is a comparative exercise.
Very important point. Hans-Jurie, now I've submitted my objection, or I've raised a query, because that's what the notice of Tshwane said. If you've got any queries, email the following address. So you might have a query that falls short of an objection in order to obtain certain information. Is the municipality obliged to answer that, either the query or the objection, and is there a time limit to that as to what a reasonable, so that you know, now I've got to appeal the determination or I've got to move things forward?
Well, it will depend on what you ask. There's always this well, in terms of case law, there's always this issue of what kind of information are you inherently entitled to, or what information you should follow the PIA Act, the Promotion of Access to Information Act, to secure information. If you want more information than what is provided in the valuation role, and it is, you will always be confronted with the situation that you will have to prove that you need that information to exercise a right. So, as I said, depending on what information, but the first approach would be, if they invite you to raise a query, they should be able to respond within a reasonable time, and at the very least sufficient time to enable you to object before the cut-off date of May that you've spoken about.
So the municipality also has to be very careful if they put out an email address.
Yes.
And if that email address is unmanned, or people are not responsive on that email address.
Yes.
Because it affects the rights. All right, that is an incredibly important point. Now, here's a question that we often get, Hans-Jurie, and this might seem a little bit unusual to you, but it is important to understand that the group of property owners in this country are diverse. Some of them are first-time property owners. And it is basically, if I object to the valuation of my property, and I say, no, my property is not R1 million, it's 750,000 Rand, does that have any effect on what I can sell my property for? will it have any,
Yes.
if I want to sell my property a year later, will somebody tell me, no, but 2 years ago you said the property is 750, now you want to sell it for $1 million?
I get that question a lot in the agricultural industry as well, in terms of when dealing with land claims. It's a contentious issue. My answer to that is simply no. It doesn't play a role in terms of the buying and selling of land. What it can be used by is by a potential purchaser using it as a bargaining tool. But what you sell your property for is what you determine the value. And what somebody buys it for is what somebody's willing to pay for it. That's willing buyer and willing seller.
And that might change from time to time.
It may change. Or somebody property is not only bought for its market value. Sometimes there's a higher premium to be paid for a property that is adjacent to your property, that you want to include in your existing property or make part of your, and that puts you in a totally different category of buyer than a person who would just simply want to buy a property. You would be willing to pay a premium for the added utility of having that property or another property, or expanding your existing operations. And no other buyer would be willing to do that. That's just one example that I can mention.
Great. Hans-Jurie, having considered these things, tell us a little bit more and give us a quick overview of some of the cases that you might know of or have been involved with that have been successful, and any lessons that you can distill from case law for ordinary people when they prepare objections that you need to highlight.
Yeah, I think most of it has been covered in terms of your strategy in following it. There has been cases where valuations were adjusted or values were adjusted. In many cases that we dealt with were more systemic. And what happened in those specific cases is small. It was smaller municipalities where somebody was contracted to do the valuations. And sometimes...
And just by systemic, you mean that the whole batch was a mess up. It wasn't just one or two. No. The whole batch was wrong.
The whole batch was wrong. And in those cases, we were actually able to get a valuer to determine what went wrong. So there are these cases. In terms of the specific objections, lawyers only get involved at a very late stage if matters is taken on review, and that would be after the objection was raised. The decision was taken by the valuer or not to approve it, and then you appeal to the appeal body for valuations, and they disagree with you, and you take it on a review. There are not a lot of those cases because you've got this municipal internal process, and secondly because of the very almost exact nature of valuations. It's not the risk of a situation where you end up with a very big dispute between valuers dealing with property valuations is very, very limited. Where cases have evolved where the process was challenged, there you find a lot. There's a specific case, and I actually read it because I regard it as a very important case. Tshwane, rural community.
That's in Mpumalanga.
Yes, the Tshwane municipality. A very interesting case where the process was challenged, not necessarily the valuation, but the process that led to the publication of the valuation, where important parts of the whole process were just not followed by the municipality. And the impact of that case must have been devastating to that municipality, because the approved budgets for approximately 10 years were set aside in terms of the rates. So they were taken back to, I think, 2009, the last time when they had a valid approval of rates.
Yeah.
And all increases subsequent to that were set aside. And that's why I say sometimes the more important part for our listeners is to be participating in the process that leads to the valuation. Public participation, play your role, make sure that your budget, because the approval your valuation and your rates is part of your budgeting process of
Yes.
each municipality, and that starts in February every year. And that whole process to play your part at providing your input, and that is also a place where you get a lot of information to see where things are going. Public meetings, I've seen many of these public meetings that people simply don't attend. And I think we need to develop a culture in South Africa, a better culture in South Africa to attend these meetings, and to make sure that it actually boils down to public participation, where your views are taken into consideration, are recorded, and it's not just the information
tick box exercise.
Tick box exercise, if I can put it that way.
So here are a few questions that have been brought to me from people watching. Peter van Vieren asks, how do you ensure that your objections are actually attended to and don't disappear into a dark hole? The practical question there.
No, it's the answer to that is to make sure you submit it to the right person. And in terms of the legislation, the accounting officer or the municipal manager, who is the CEO of each, or municipal, the metro manager in terms of in Tshwane, your document needs to be submitted to the municipal manager. And the best way to avoid a situation where emails and that kind of communication is a very effective way of communicating, but it also provides a very easy excuse for people to say they didn't get your documents, is to take a hard copy, 2 copies, go to the municipality, hand in one, and get a stamp on the one that you submitted. That is the most.
That's the belt and braces.
Belt and braces approach, and make sure that it's there.
What we have in Tshwane is an address has been advertised as for email purposes, and I'm sure also, email, as much as it provides an excuse, it also gives you a time and date stamp,
yes,
which I guess is also useful in that sense.
It is, but it's no guarantee. In litigation, our course regards email as a very important way of communicating. Usually it is used and accepted as a form of communication. But I've also seen court cases where excuses are tendered that we had a system overload, or we had a technical glitch in terms of receiving our emails. It's not a fail-safe exercise. If I would give somebody advice that walks into my office, I would rather use the manual and most trusted system.
Okay, belts and braces, says Hans-Jurie. The next question is, and I'm not going to say this person's name because he might want his privacy protected. He says his property valuation is 22.5% less than what is shown So I'm guessing the question is, he's actually, the city has done a valuation that's less than the market value. What should he do about it? And I'm guessing it's a matter of you object when your property valuation is too high, but I suppose you could argue that it's too low.
Well, if you're a principled person, you can obviously go and say it's usually why people would not be happy with valuation is simply the bogeyman story that you spoke about earlier, that people say, well, if my property is valued at a lower value, a possible future buyer is going to use that to reduce my price. I had some examples of people doing that, but if that is the value that the city evaluator determined through the exercise that they've used, obviously I would not object to that. It doesn't play a role in the actual market value of the property. If you want to sell the property, what I suspect happened here is simply that by virtue of the fact that it was a desktop exercise, certain critical information, that's why I've used that example, certain critical information about the property could not be detected via the other means that they employed to do that valuation.
Professor Terence Komal asks, could the residents launch a PIA application, that's Promotion to Access Information Act application, to demand the records and to see how valuations were done?
Yes, probably, because if it is for purpose of the exercise of a right, I cannot think for one reason why they would not be entitled to that information. PIA emanates from the Constitution that gives you a right of access to information held by the state in order to enable you to exercise your right. So in principle and from a legal perspective, I think they should be able. The only difficulty is time in terms of if you want to object. But if there is a glaring mistake or in the process, if a systemic mistake, I think will be worth the while. My concern with regard to PAIA is that sometimes the Act is well intended, but it also provides time frames that enables delays.
It might not be useful for the purposes of this process,
but for a totally different reason, for a legal challenge to
the whole process.
To the whole process, yes.
So then Jacques asked, my plot, so it's small holdings, is classified as residential. And I'm guessing it used to be agricultural, now it's residential.
Yes.
Tax is up 376%, but we don't have services except water. And what he means here is that many small holdings get their electricity from Eskom. They've got gravel roads, as I said before.
Yes.
What can Jacques do, presuming that what he does on the small holding at least includes some agriculture?
Well, the area, it's a strange scenario. If it is a small holding, and that is the scenario, it should be part of a urban area that is used for agricultural purposes. So what I would recommend you do is to go to a town and regional planner to make sure what the actual zoning is, or actual use is, to see whether it corresponds with what the city valuer contained. Obviously, there can be an argument raised to say, but it's not just residential. I should be entitled to the rebates that somebody in the agriculture or bona fide farmers are entitled to.
And that wording, the bona fide agricultural activities, that is also a definition that's given in the city's bylaw.
Yes.
On property rights.
Exactly.
And you can make the argument perhaps that on 50% of your land or 20% of your land, you in fact do agriculture and the rest something else. Yes. So that you don't get slapped with a higher tariff, but it will actually depend on what is happening on the property.
On the property. One of the other ways to deal with agricultural land is to be a member of your local agricultural union, because they also engage with the local government, and if you are a member, that will give you the advantage to say, but not only do I use my land for agriculture, I'm also a member of the agricultural union. That's another way of going about.
Here's an interesting one. It's very specific, but it's interesting enough for us to cover. The person says, sublet or run a property as Airbnb. Can the classification or the categorization be changed from residential to business? Is that something you want to answer?
No, I'll answer it. Obviously, if you conduct a guest house, there's legislation, it's regulated. So, but if you look at the legislation, it doesn't only talk to your actual approved use. It talks about what you use it for, and a rate can be imposed on you for what you use it. So if you are not a guest house or business, the municipality, if they detect that you are conducting a business there, they may be able to say, well, now we're going to impose the business rates on your property. So I don't know if I'm answering the question correctly, but if you succeed in using it for household or residential purposes, it's fine. But if you may end up in a situation in future, or a neighbor may report you to the municipality, and then you may be faced with the situation that you're going to pay a lot more tax, because business are paying more tax.
The business category does pay more than the residential category. Then Amanda asked, can a residential complex object as an entity, or must each individual owner, I'm guessing it's a sectional title, must they object separately?
Separately, the Act actually makes specific provision for sectional titles, and each individual sectional title owner must object individually for their exclusive property in a sectional title. But you may have a different scenario where you have a body corporate. There are other ways that people hold land in common or in a security complex that are not sectional titles. But the Act talks about each individual owner must then object. If it's a systemic issue, then obviously one can do it in a coordinated collective.
So everyone individually, but you coordinate your efforts. Quickly talk to us about rebates, exemptions, and exclusions.
Yes, the Act allows for rebates, exclusions, as you've said, and the circumstances under which that is allowed, you will find in your rates policy. Meaning the municipality doesn't have a discretion to, in one instance, say, I'm going to accommodate you and give you or charge you a smaller rate. The specific exemptions, exclusions, and rebates you'll find in the policy and under which circumstances it can be allowed. So, in a broad approach, would be to look at your rates policy to see whether you qualify, and if it gets charged to your and you see that you don't get it, but you should qualify. That can also be one of the reasons why you object, to say because I qualify. That is something that a valuer, city valuer, will not be able to determine.
Those are your individual circumstances, and perhaps if I could just add to that, what we have is there are certain exemptions which apply to pensioners.
Yes.
So if you're on pension or not working anymore, the municipality must, if you've lost your job,
yes,
if you're unemployed, but you have a property on which property rates are paid, there's also a provision there to give relief.
Yes.
And in each of these instances, the local councillor should be able to assist the property owner to say, listen, I lost my job at this stage, I went on pension on that stage, and it's important. There's one other aspect here, and that is in each municipality, the municipal council also decides which portion of the value of a property they don't want to tax. In the city of Tshwane, it has typically been the first 150,000 rand
yes,
of a property. And I think the important point to make as well, and you can comment on this, is it's not just about the valuation of the property. It's not just about the category of the property. There are certain things that a council can do to relieve the tax shock or the tax pressure.
yes,
And to me, the two things I've mentioned to colleagues is one, the council can decide to put a 0% increase on the tariff. So you get the valuation, you get the category, and then you get the tariff, which is determined in the budget.
Yes.
Put that on zero compared to, put the increase on zero
yes,
compared to the previous. That would be a relief. But another relief would be to increase that threshold, that portion on
Yes.
which you don't pay
yes,
property rates.
yes. That you're correct. Council can also play a role in looking at the economic side of things. That I think the question should be, what can you do politically?
Because all of this stuff has been technical, valuer,
Yes,
market.
it's by law. Yes,
It's by law. It
Yes.
should be by law.
Yeah.
But then there's the political aspect of it as well.
Yes.
And we saw it with the budget, with the DA fighting back against VAT increases, delaying the first budget speech, and now we're sort
It's
of
political.
on tenterhooks. It's political.
It's political. At the local government to a lesser extent. But if you can look at the exclusions or the exemptions and rebates, there is a sensitivity with regard to people's financial position, and I think that should play a major part. And then the other part where I think council should also play a role, and from a political point of view, is oversight. Oversight over the process, oversight of who conducts the valuation.
Councillors, technical.
Councillors are in a better position to determine systemic errors, and then to inform residents and perhaps challenge that.
Hans-Jurie, we've run out of time for this webinar, but I think we've covered a lot of ground. A lot of the questions that we received was about forms and laws and regulations, and let me give the assurance that we will send you all of the forms, all of the links where to access the valuation roll. Everything will be sent to the participants who registered for this webinar, but will also be shared, as we have been doing it, with ward councillors. So if you don't know your ward councillor, get involved, join the WhatsApp group, ask these questions. And then finally, this final issue that we raised, from the DA's perspective, we'll also fight for a fair deal on tariffs. Thank you very much for joining us.
Thank you.